On the 27th of December 2022, the Commission sent you a request for submission of the 5-year declaration of assets and personal interests. And on the 2nd of January this year, 2023, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did so on 3 July already last year, 2022. The Commission sent you 4 rounds of questions on 31st of January, 13th of February, 21st of February and 24th of February, respectively. You were asked a total number of 20 questions, including 53 subparts, and 35 of the questions included a request for further documentation. According to Article 3, Paragraph 4 of the evaluation rules of the Commission, a candidate may not provide information, documents or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless of course the candidate provides sufficient justification. Members of the Commission will now start with asking you questions, and Nona Tsotsoria will start with asking questions first. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Nona, I give you the floor.
Welcome, Mr. Caisîn. The first issue concerns the sources of funds for procurement of a 47.7 square meter apartment located in Chisinau on 11 November 2022. In the first round of questions, you confirmed that on 11 November 2022, you and your wife purchased a 43.7 square apartment located in Chisinau for $33,000. You presented a copy of the sales purchase contract authenticated by a public notary. According to the contract, you paid $21,500 in cash before signing the contract, and the remaining amount of $11,500 was to be paid before 15 November 2022. You also indicated that full payment for the apartment was made on 12 November 2022, and you submitted a copy of a declaration on extinguishing the debt, also authenticated by a public notary, as confirmation of payment of remaining amount of $11,500. You explained that the following 4 sources of the funds were used to buy this apartment and provided copies of 3 loan contracts. First loan contract of 9 November 2022 between your wife and EC for the amount of €15,000 and $1,400 to be reimbursed €5,000 before June 1st, 2022, and the rest upon request, with no interest to be paid. You submitted a copy of receipt confirming the receipt of this amount by your wife on 9 November 2022. Second loan contract of 14 November 2022 between your wife and the company DC for the amount of 100,000 Moldovan leis to be paid back by 1st July 2023 with no interest rate. You submitted a copy of a receipt confirming receipt of this amount by your wife on 16 November 2022. And third, financial aid contract between you, your wife, and AR for the amount of €6,000 to be reimbursed by 19 November 2024, including the inflation rate. You submitted a copy of a receipt confirming the receipt of this amount by you and your wife on 19 November 2022. And the fourth source of funding was your personal savings in the amount of 40,000 Moldovan leis, 6,000 Moldovan leis, and €3,300 accumulated from lawyers' activities, dividends received from ZC, this is your wife's company. In the third round of questions, you were asked several details about the 3 loans you indicated as sources of funds for the apartment and to explain how you were able to use the amount of 100,000 Moldovan lei from the loan provided to you on 14 November 2022 and the amount of 6,000 euros provided to you on 19 November 2022 to make the remaining payment of $11,500 on 12 November 2022. In your written reply, you explained that the declaration on extinguishing the debt of $11,500 was signed on 12 November 2022 because the sellers had a flight to leave the country on 14 November 2022. The sellers agreed to sign the declaration on extinguishing the debt, but it was not provided to you until you paid the last part of the debt. You explained and provided confirmations for the payment of the remaining debt in three tranches via bank transfers on 17, 21, and 22nd November 2022. Only after that, a friend of the sellers provided you the original of the declaration on extinguishing the debt, signed by sellers on 12 November 2022. You also explained that EC agreed to provide your wife a no-interest loan of 15,000 euros and $1,400, out of which only 5,000 euros to be reimbursed before 1st June 2023 because that person is a friend of your wife and needed only 5,000 euros before June 1st, 2023, while the rest could be returned after the other 2 loans are reimbursed. You provided confirmation that 100,000 Moldovan lei loan was provided by the company DC as advanced for salary. You also indicated that AR agreed to loan you 6,000 euros with only the inflation rate to be covered because of the trust in your capacity to reimburse the loan. I will begin by asking you some questions to establish facts. Hopefully they can be answered with yes or no response, and later I will ask some questions that will seek greater detail or explanations from you. Please explain if you disagree with any of the facts stated above.
Well, it feels like that was an accurate representation.
Thank you. Please confirm that you bought the apartment on 11 November 2022 using 4 sources of funds, 3 loans and personal savings in the amount of 40,000 Moldovan lei, 6,000 Moldovan lei, and 3,300 euros.
On the 11th of November, I paid the amount from EC, that I took from EC and from our own resources, 21,500, if I'm not mistaken. And the seller, she needed to travel to Moscow, or actually to a town next to Moscow for some healthcare-related issues. And it is my understanding that she had the tickets, flight tickets, on the 14th of November at 4 a.m., 14th of November, 4 a.m. The flight tickets was for the date. And we didn't have other resources other than, we were thinking about taking a loan from the bank, but there were all sorts of delays. It was either issues with the documentation, and there was supposed to be also an evaluation carried out. And at that time, we decided to have this declaration in place that it was fully paid, but it needed to be given then to us for us to record it with a cadastre, and that would happen after the full amount would be paid. And the full amount was paid, as according according to the information that you've indicated already. And then recently we registered our ownership rights, because what we had in place at the time was something temporary. I mean, the Public Services Agency would record the ownership in a temporary fashion in these situations, but later on, once everything was paid in full, we were able to register our ownership rights per se.
And please explain during which period or which years you and your wife made the personal savings in the amount of 40,000 Moldovan leis, 6,000 Moldovan leis, and 3,300 euros that you used for the apartment.
So 21, 22, these are these, 2021, 2022, which is when the ZS enterprise was set up, that was purchased from somebody else. And there, the DC company as well, the other enterprise that received the advance payment, there was an agreement on provision of legal services. However, there were certain situations in the courts, and the courts would ask for an order, and my wife had to be hired there as a member of the staff to be able to do representation. So the agreement according to which she was employed was changed from a mandate into services provision, into full-time employment, actually. So, and that's about the dividends. And then there were savings from myself working as a lawyer, and as a lawyer also providing state-guaranteed legal aid at the National Center for State-Guaranteed Legal Aid. In July 2021, I've entered into this agreement with a legal aid center. And so there was a contract on legal assistance to an enterprise in the town of Belts as well. So these were the sources that allowed me to accumulate those funds. And if you notice, there was also a question in one of the rounds. There was a question about 100,000 accumulated in one particular account. That's a salary account that is based on, well, actually, there's a number of factors there. You've said 126,000, I think it was, 126,000, I think. So those were the key sources. The salary of my wife, which was, after we paid taxes, there was about 15,000 leis. So we put these amounts together so that, first of all, I mean, considering the delayed submission of declarations of the tax return, so we had to pay the taxes, and so that's why we were also making savings. But this situation regarding the apartment, you know, it was very spontaneous. We didn't want to purchase it. We were not willing to buy this apartment. That person was our neighbor. And she lived in apartment number 9, and I lived in apartment number 11. So she came to us. She said she was 72 years old, and she was living all on her own in Moldova. So she wanted to her relatives. She had relatives in Ukraine, and she had relatives in the Russian Federation. So such a paradoxical situation. However, she decided to go to her brother's place. Her brother came here. We assessed the value of the apartment together, and we didn't want to, because initially we went to the bank, and the bank would not be very straightforward, or they were asking for some additional documentation. So thus we turned to the friend. If that was possible, then all right. If it wasn't for the friend, we would have never made that procurement. We didn't have this money. I'm going to say that from you, honestly. That's my work as a lawyer, a contract-based activity as a legal aid lawyer, and the salary of my wife. In 2021, she worked there in that enterprise. And then in 2022, in early 22, I think she already had a full-time employment as member of the staff, but until then it was a different type of contract with that company. So these were the sources for the 3,000 euros and for the 40,000 lei.
Thank you. Is there anything you want to add?
Well, I am just saying things the way that they exactly happened. That person came to us and she said, she said she needed to undergo some healthcare procedures because she needed to have a surgery, and she had already gone to the Russian Federation, actually, and where she had relatives. I mean, she was here for a while, and then her relative, her brother, came over, and we decided to, after having talked about it, we decided, because, I mean, that person, I've known her since back in 2008, when I met my wife, and my wife has been living there since she was a child. They have been neighbors, lifetime neighbors. And she just suggested us, like, if you want to, and we thought we would want to because it was on the same floor right next to us, but unfortunately we didn't have the money. So as I said, we went to the bank, but it didn't turn out well. It was not possible to do it through a bank, and then we asked EC, her friend, and she gave us this possibility. So she was the key. If it wasn't for her, we would have never entered into this agreement. It never would have made this transaction.
Okay, now let me move to issue number 2, which is related to non-payment of income taxes for 2018 and 2021. In your 2018 to 2021 declaration submitted to the Commission, you declared income from Valentin Caisîn lawyer's office totaling 762,922 Moldovan leis. According to the State Tax Service, no taxable income was registered in your name in the period of 2018-2021. The information per year is presented in the table which is given to you this morning as well. In reply to the first round of questions, you presented to the Commission digital copies of the income declarations you submitted to the State Tax Service on 2nd February 2023 for the period 2018-2021. According to those records, a total of 72,562 Moldovan leis was calculated as taxes and 2,226 Moldovan leis as penalties for the entire period. You also stated that taxes were paid with delay, due to which the penalties were calculated. In the third round of questions, you were asked to submit the copies of the documents confirming the payment of taxes and to explain why you submitted the income declarations to the State Tax Services only on 2nd February 2023. You replied that you acknowledged that you submitted the income declarations to the tax office with delay. You further explained that you were not able to pay the income tax during the period of 2018-2021 due to your difficult financial and family situation, and that only since 2021, after you signed a contract with National Legal Aid Council to provide state-guaranteed legal assistance, you started having a stable income. That allowed you to pay during 2021-2022 all your debts, including credits and loans. You also explained that as of 23rd February 2023, your total debt for the income taxes was 29,375 Moldovan leis, which you would pay until 3rd March 2023. You indicated that you had already paid 43,186 Moldovan leis out of the total amount of 72,562 Moldovan leis. You did not provide any proof regarding the payment of the taxes in the amount of 43,186 Moldovan leis. Here again, I will begin by asking you some questions. Please confirm that you did not pay your income taxes from activity as a lawyer during the period of 2018-2021, as indicated in the facts I just read.
Yes.
Please confirm that you submitted your income declarations from your activity as a lawyer for the years 2018-2022 only on 2nd February 2023.
Yes. They were in my the personal account But the STS was supposed to confirm receipt, but I mean, there were some delays there. So I admit to my fault in this regard. The only thing that I would like to clarify, if that is possible, as for the 72,000 and the penalty was 20,000. 20,000 penalty for 4 years. I mean, for 4 years it couldn't have been 2,200. It's 20,000, and I've already paid this interest rate. Unfortunately, I was not able to provide the details of the personal taxpayer's account. I wanted to take that. I mean, it's actually 9,300 lei are yet to be paid. What 9,300 yet to be paid? Yes, on Friday I was supposed to pay that up. However, it was in the beginning of the year, I was supposed to receive from the enterprise that I provide services to. There was supposed 6,000 lei to have come to the account. I was supposed to add 3,000 to pay it up, but I didn't manage to. It just didn't take this statement of the taxpayer's account from the tax administration, because usually in this personal account of the taxpayer, there's all these details, but I didn't take it now.
Okay, let's continue then. Please confirm that you submitted your income declarations from your activity as lawyer for the years 2018-2021 only after you received the question in this regard from the Commission on 31st January 2023.
Well, it was earlier than that, after the declaration, the 5-year declaration was submitted with the Parliament. On my personal account, I kept that information there, but I didn't understand very well how to work with the USB stick, what to do with it. But on the, 2nd of February 2023, I filed it, so it turns out it turned out that after the question was raised. I have no other way to provide any other proof, but that is the truth.
And you may want to explain why you submitted the income declarations for your activities as a lawyer for years 2018-2021 only on 2nd February 2023.
Yes, as I explained, you see, from 2014 when I resigned, then in 2015 I became an intern lawyer, and in 2017 I was on internship. In 2017 I got my lawyer's license, and to be honest, I was at the Ministry of Justice. I was given the license and sort of go and do whatever you want with this license. There was no support whatsoever given to me. I mean, if you pay a little attention, I also listed the credits I took in that period, so as for me to be able to meet ends. I did not have one client at all. So in 2017, I was supported by BioProtect, and I had some revenue. And then my wife, until 2020, did not have a job. It was we went through very hard times, and it was my income was the only source. I mean, you can check, she did not work anywhere at all. She was looking for a job and just couldn't land one. And this is what things were like for us.
Okay, I still come back to the total amounts, and just to make sure that we have proper records of your statement. Please confirm that the total income of taxes you owned for 2018-2021, according to the income declarations you presented to the Commission as of 2nd February 2023, was 72,562 Moldovan leis, and as you confirm now, penalty in the amount of 20,000 Moldovan leis.
Yes, 20,200 something. I mean, it would have been impossible for 4 years to have a penalty of only 100 euros, that is 2,000 lei, impossible. And there was a debt there. When I looked at it, the debt was 93,000 lei, I think. 93, a little bit more than that maybe, but around that was 93,000 lei. That was taxes plus penalties. because I was supposed to pay the taxes, and I was also fined by the STS for not having paid the taxes. So I am the only one to be blamed in this situation. There's nothing I can do about it. It's my fault.
Please confirm that in the third round of questions, you informed the Commission that as of 23rd February 2023, your remaining debt for income taxes was 29,375 Moldovan lei, which should be paid by 3rd March 2023.
So the 23rd of February, right? 23rd of February. Yes, that week, there was my sister. She lives in the US, and she found a job there in the long run, and she helped me out with paying that. And in addition to that, there was some income from some contracts and from the Council for State Guaranteed Legal Aid. I think they transferred about 7,000 lei to me.
And I did pay, but I still have that 9,000 lei debt right now. But unfortunately, I did not take an abstract from that website.
And did you pay the remaining debt of 29,375 Moldovan lei yet?
20,000 was paid, or even 29. 9,000 is left. I'm saying right now. I was supposed to pay this amount on Friday. So I received a fee. I should have received a fee of 6,000 lei from the company, and I had to add 3,000. But unfortunately, the company did not wire the money, and I couldn't pay. But today, tomorrow, I will pay this out because the penalty is growing.
Okay. Please confirm that you did not provide the Commission any proof of payment of the income tax in the amount of 43,186 Moldovan lei, as you indicated in your reply to the third round of questions.
Yes, this amount was collected through incasso from the STS. The only proof could have been that abstract from the personal office in the system, but I did not do that, unfortunately. But it is paid. I don't know.
Okay. Please explain the source of your savings in the amount of 40,000 Moldovan lei, 6,000 Moldovan lei, and 3,300 euros, as we discussed in the previous question, in view of the fact that you did not have sufficient sources to pay your income tax in the period of 2018-2021.
That was from my lawyer's activity, and I said, my sister helped me as well, but at that time, that was money from my lawyer's activity, and that was from December, because almost everything was paid, like no money was left in our house. We did pay everything for that apartment.
Okay, please add anything you find important in regard to this issue.
Well, please only take into account that I had a difficult situation, but of course it's up to you to decide.
I'm done with this.
Sorry, Vitaly, please go ahead.
Mr. Caisîn, good morning. In order to reach a certain conclusion about that issue, I have a question. With respect to not paying taxes, as mentioned before, on 2nd of February, you filed your statement to the STS, and then you paid the outstanding tax and the penalty to them, most of it. And my question is, what made you, no, please let me continue. What made you try to correct the situation now? Well, I wanted to show good faith in front of you. I did not hide anything about my income. I declared this income to the Parliament in March last year, the same things. I also declared this in front of you in the 5-year declaration, the same income. But when it comes to the STS, I found the settlement, well, that was, they were in the personal office, in the account, in the in the system, but some special procedure was needed for them to be accepted by the STS. But that happened only on February the 2nd. By that time, I have already been to the STS and they showed me the procedure. And another additional question here. This approach, trying to remedy the situation, was caused by the fact that the Commission approached these topics? If not, when were you planning to do that? Well, I should have done it, and I gathered the financial resources previously. But you see, we had this apartment situation where all financial resources that we said we had to go towards the payment for the apartment, but well, it's my fault. I'm guilty. Yes, I accept it. Your answer is accepted. Thank you very much.
Yeah, please, Nadezhda, go ahead.
Domnule Caisîn, vă mulțumim pentru răspunsuri. Mai departe să vorbim.
Thank you, Mr. Caisîn, for your answers. And next we'll talk about another action, about the disciplinary sanction. If you can't hear it, you can make your sound louder. Well, on 3rd of June 2019, the Board of Ethics and Discipline of the Bar Association of the Republic of Moldova issued a decision on your disciplinary misconduct in exercising a lawyer's profession based on your license. According to the decision, on 17th of April 2018, 11th of June 2018, and 9th of October 2019, I will not use the full name, we'll use only the initials AR, and that will be the complainant hereinafter. So, the complainant entered into 3 contracts for legal assistance with you in the interest and for the defense of IG, for which he had to pay you 30,000 lei for all 3 of them. The Board for Ethics and Discipline concluded that you committed a disciplinary violation and issued a warning to you because in the board's opinion, you did the following. First one, you received several amounts without issuing invoices, and you did not mention in the legal assistance contract the real amounts that you collected as a fee from the client. The Board for Ethics and Discipline found that in 2018, you received several amounts from the complainant for which you did not issue receipts, and the receipt that you issued on the 3rd of January 2019 did not justify your actions in the board's opinion because they were issued only after the complainant asked you to return the full amount as provided in the agreement, and these receipts were not signed by the complainant. Secondly, the complainant did not benefit of you performing your obligations in good faith in line with the law, the signed contract, and good morals. And thirdly, you did not consult the client thoroughly and did not inform them with due diligence about the progress of the case that was entrusted to you. I quoted that from the decisions of the board. So please confirm that you were sanctioned by the... Yes, of course, there was a warning. And do you confirm that the decision was about 3 matters? Like the first one, we can call it like bookkeeping, let's say. It was about receipts. And second and third related to the way you provided legal support, meaning that you did not perform your obligations in good faith and you did not thoroughly consult. Well, that was in the decision. Yeah, that's what's said in the decision. I explained you all the circumstances about those cases. If you believe that that's it? No. I'm only asking you to confirm that that is written in the decision. Thank you. So, when answering to the second question of the second round, you provided a lot of information about the allegations of a complainant against you and conclusions of the Board for Ethics and Discipline. Namely, you provided information that you represented IG in the criminal case number 1. Well, just give him a conventional. And you said that on 17th of April 2018, you concluded a legal assistance contract in order to represent him. That contract required the payment of 15,000 lei for representation in 3 levels of courts: first instance, appeal, and cassation. And the complainant paid your fee for you to represent him in the first level court, 5,000 lei. You mentioned that you took part in 17 court hearings on that case, and you submitted an appeal against the conclusion of the first level court on pretrial detention of a defendant. You said that your appeal was accepted by Belt's Court of Appeal. At the same time, on 3rd of January 2019, you received a unilateral notification from the complainant on the termination of a contract of 17th of April 2018. You also stated that you received no explanation about this unilateral termination of the contract. Nothing. They just came and gave me that paper. In response to the 4th round of questions, you provided a copy of that unilateral termination notification that referred to all 3 contracts. In the second criminal case, you concluded the contract on the 11th of June 2018 to represent them in another case. It was for appeal. The contract was providing for 10,000 lei payment for representation in 2 levels, appeal and cassation. You mentioned that the complainant paid 5,000 lei to be represented at the Court of Appeal. You also mentioned that you submitted an additional appeal and you took part in 17 court hearings in this case as well. Additional appeal. At the same time, you again mentioned that on 3rd of January 2019, you received the same notification of unilateral contract termination with no explanation. You also said that on 3rd of April 2019, you received summons to take part in the court hearing in the Court of Appeal, where the defendant informed that the defendant said that he would be represented by another lawyer. Is that right? Right. The third aspect, you said that you concluded an agreement on the 8th of October 2018 to represent IG on 3 contravention cases. That contract provided for 5,000 lei for all these 3 cases. Again, first level, appeal and cassation. You mentioned that the complainant paid you 5,000 lei. You stated that all 3 cases had been examined by the end of 2018. Yes, by the end, not examined. First level court decisions were issued on them. And at the same time, on 3rd of January 2019, you received the same type of termination notification. Just a second. So, in conclusion, you informed the Commission that, according to the 3 legal assistance contracts mentioned above, the complainant paid you 15,000 lei in total, which were accounted for by the lawyer's office, Valentin Caisîn, and 3 invoices were issued and sent to the complainant, but he refused to sign them. You provided a copy of the 3 invoices to the Commission. You also declared that in all those cases, 2 criminal ones and 3 contravention cases mentioned before, you tried to act diligently in the interest of the defendant. Indeed, you mentioned that you did not appeal the decision of the Ethics and Discipline Board in court. And I will quote here, considering that this will be a lesson for you for your future activity. Correct. In reply to the second round of questions from the Commission on 15th of February 2023, you mentioned that you submitted a request for the revocation of a decision in the disciplinary case of 3rd of June 2019, and you provided a copy of that request. In the same answer, or in that request, the date of 25th of February is mentioned as submission date. Please, about revocation, please let's leave it out. This was a civil case. I will tell you as it is. It was a civil case, and it was of that lady against me, and it was. And I filed that request because you see this decision sanctioning me. It's not right. I felt it's not right to me, but I did not challenge it before because still I believe that's a lifelong lesson for me. No matter how hard the lawyer works, if the client loses, you are to be blamed. So there is no case, and there was a situation. Is it possible? No, I understood. You confirmed these facts, that so far what I said is correct. I have some more facts to mention for you to confirm, and then we'll move to questions, because that is the essence. In the third round of questions, Commission asked you to explain what you meant by this being a lesson, and you said that this case was among the first cases. It was my second case, actually, after obtaining the lawyer's license. You said that you worked diligently on that case. You discussed daily with the complainant, explaining every step to be taken in criminal and contravention cases, and that you explained repeatedly to IG the need to come to court. I explained it to him not only once, but in the meeting of 20 of December, I called him 43 times. And this person who never answered. I called him for 43 times to come to me because a prosecutor was asking for a replacement of a measure applied. I'm telling you as it was. And, well, I saw that, all of a sudden, see that the prosecutor made that request in another court hearing in my absence. When I wasn't there, there was an ex-officio lawyer, and they examined that request, and the preventive measure was changed into arrest. So despite of your insistence, Mr. IG did not come to the court hearing of 30th November and some in December. Yes, 3 consecutive court hearings. So you said 4 to us. No, 3. I remember that for the first one he was late, and then for 3 consecutive hearings he did. I'm saying as it was. I called him 43 times. I called him continuously to get him to come to court, but he was not answering. And in the court hearing of 20th of December 2018 that took place in your absence, no. So it was appointed for morning, but the meeting with another lawyer took place in the afternoon. In my absence, they didn't even say that such a request was submitted, and another lawyer was invited. I sent you the decision of a court of appeal that examined. Mr. Caisîn, may I? Because now you present facts a bit differently than before. So do you state now that on 20th December 2018 you had a hearing in the morning that you attended? No, I was on a sick leave. I couldn't come. But it wasn't that morning meeting, but there was another one in the afternoon. So I believe the judge called the lawyer ex officio, so in order to be able to examine this request. This is how I see things. I want to understand. You received summons to go for the 20th of December morning, but you did not come because you were on sick leave. We did not receive summons, not summons, but you were informed because the trial was going on, so you don't need summons anymore. And 3 consecutive hearings were established. So the hearing was established for morning of 20th of December. But in the afternoon, but you did not come because you were on a sick leave. Yes. And I informed who? I informed the judge. Did you inform the defendant? I informed the judge. And we talked the day before with the defendant to come because I am on sick leave and he had to attend. So you informed the defendant to attend. Did you inform him that you are on sick leave? I don't remember this. I know that I talked to him to attend the court hearing because there is a danger that it is possible for the pretrial measure to be replaced because he missed 2 consecutive hearings, and that's why there was a risk. We can look into the minutes of those hearings, and the Court of Appeal mentioned that because it was there was a decision of a Court of Appeal in the absence of the selected lawyer, and it was like almost secretly done. Not the request was not sent to me, not even the date. So that is mentioned in the decision of a Court of Appeal. That's it. I understood that. Thank you. And now about the following. You explained that you submitted a revocation request for the decision of 3rd of June 2019 of the board. That's based on Article 140 and 170 of the Administrative Code. Yes. If the Commission cancel it, so that request for revocation is an internal matter. Yeah, you see, let me please finish my thought, because this is what we want to understand, what you wanted to say through that request. I apologize. So you did not provide any documents on the result of that request, right? The meeting is supposed to take place today, the hearing, the meeting. But I will withdraw that request. Well, let's clarify then the following. Do you confirm once more that you did not contest, not appeal the decision of the Board of Ethics? No, I did not. You said that you filed a revocation request, right? Yes. Okay, please explain what that revocation request was. An emotional act of mine, but I will withdraw it from the Board of Ethics. Understood. Let me explain you why we had questions about it. According to the law on lawyer's profession, if no new disciplinary violation is committed within a year, 59. In the context of that provision, we could not understand what's the reason behind this revocation request. You see, you asked these questions, and I was thinking back to the situation. I was like living it again, and it was my first criminal case, actually, first 2 criminal cases, and we worked with the witnesses and all of that, and finally, I mean, I understood. The mother of IG, she saw that the pretrial measure was changed, and she said, let's terminate all contracts for lawyer support. And I explained, there is cassation. She was speaking Russian, and she was saying, like, you don't know how many, like, sort of food or whatever things to bring to, I have to help a lot while he is in detention. And I tried to tell her, wait a little, we will challenge this, because the decision of the first level court is not right. And I found it, even though she was, like, strongly against me, and they invited another lady lawyer, I still filed that challenge because I felt that that situation was not right. And the decision of the Court of Appeal said that that situation was wrong when almost secretly, without the selected lawyer, to decide on replacing the pretrial measure into the most severe one. So, out of the documents that you submitted and the explanations that you submitted, that you filed that appeal despite receiving the notification. No, that was before the notification. The notification was on the 3rd, but I filed the appeal on December 30th, I think, if I'm not mistaken. So I filed, even though I already knew, because she called me on the 28th, he was apprehended. He was walking on the street and he was apprehended by police and taken to the pretrial isolator. And his mother called me, what happened, why that? And I did not even know that such requested, but I was suggested that kind of missing 3 court hearings, and he had a prior, like a criminal case in the past, and I asked him, please come to the court hearing, but he was apprehended, and his mother called me, and I just did not understand. Please pay attention. Like the decision was issued on 20th of December, and I received the conclusion on December 28th. And I was shocked by the conclusion of that judge. But we appealed it, and we won that case. Won the appeal. She was telling lots of things, but you asked me these questions, and I was reliving that situation, and you know, it's... your revocation request was emotional. It was emotional. Has no legal effect. It's not about having no legal effect. You see, well, it has no legal effect. Okay, let's put it like that. Well, please, no, tell me what you think. I acted as I used to be a judge. And every case, well, it was a struggle. I think this is how I perceive things. And that was my first case as a lawyer. And the state prosecutor was a little, well, had a rich fantasy, a rich imagination. And I saw that the situation could be improved. There were 3 accounts, and we could work and leave only one and exclude the others from the prosecution. I knew that, and I received well, and I just felt this emotional, and you asked me those questions, and I was thinking, like, time has passed, and even now it's again about that. So I'm sorry, but this is important for us to understand. Everything related. Okay, let's say the revocation request has no effect, but it is about bookkeeping aspects, and the others too. The information as well. I listed all of them. Yes, all circumstances, because you see, it seems like I had a client. It wasn't, not the woman was the client. The IG was the client. He was grown up, full age. I worked with him, and all of a sudden his mother comes. And the situation is not like I had to inform her, even though I informed her, because she was calling me every day regarding that file, that case, sorry. Well, but given that that was your first case, and it was regarding to matters in ways that you provided legal assistance, why didn't you challenge this decision within 1 year? You know, for me, that was a lesson, first of all. I'm honestly telling that. No matter how the lawyer works, the lawyer is to be blamed in the end, because like, I was not there. I appealed, but I wasn't next to him, not on his side. Well, from all the answers you provided to the Commission, we can see that you disagree with the conclusion of the board. I agree. Let's say that I agree with the board's decisions. Well, what can I say now? That was back in 2019. Like, I want to the SCM, I want things to change in the country, I would change the situation. But back then, if you think that it was my fault, let it be like that. No, we cannot consider you at fault or not. Well, we could look into affairs because he's convicted for 7 years. But it was possible to get him out of that. Thank you.
Yeah, I don't have any questions. Anyone wants to follow up?
Mr. Caisîn, you explained in plenty of detail all the aspects, but I would like to ask some questions. In 2019, under disciplinary verification, that disciplinary sanction, a warning, yes, was issued to you. And under that, during this mission, you say that you disagree with that decision. At first stage, you said you disagreed. At the last, you said that you agree with that decision of that board. I start from the decision, from the idea. If you, as you say, initially disagreed with that decision, if you look at the timeline, why didn't you undertake measures to challenge that decision? That was my first question. And secondly, you provided a request to the Commission registered on 25th of February 2023, where you demand revocation. And I would like to ask you again, what caused you to want this? Am I mistaken when I say that this issue was, because the Commission addressed that?
You see, you asked those questions, so I thought back to that situation again. It's like I lived again through the same feelings that I had at that time. Because from my point of view, there was no sanction, there wasn't this warning wasn't there. It's just, you see, if you have an issue with the Commission, then I decided to leave it at that. I mean, for myself, I thought it was going to be like for the future. In the future, I will remember this situation that I have gone through it. But of course, I had to challenge it. Of course, I had to, because it's just now, if I were to swear with a hand on my heart, then I think I would have challenged it back then. I accept your answer. Thank you.
Mr. Caisîn, I also have a follow-up question on this. You just stated, and that was actually my first question, whether you agreed or did not agree with the decision by the disciplinary board, and now you indicate that you do not disagree. And you also said that this will be a lesson for you. What lessons did you take from that? What is it that you saw at that time that you would not do now again, and that you would do differently in your present practice?
Domn președinte, nu greșește doar acea persoană care nu trăiește.
Only a person who doesn't live and doesn't work doesn't make any mistakes. But you see, there was this situation when we were interns in Moldova. You can't participate in contravention criminal cases as an intern lawyer. So how do we keep these records? I mean, is it at the end of every stage that you keep records of it? For instance, the different levels of the court. What I knew was, you see, I had to travel all the way to Belt and then return. And that is hard, doing all this travel. And it was also about the accounting part with regards to the expenses incurred for the travel. So I thought we were supposed to show this at the end of the period. So that's why I'm understanding of how to provide the information for travel expenses to be reflected into the accounting, but then I understood that I had to do this every time. So this is the first lesson that I learned about it, these accounting procedures and reporting expenses. And I believe also that a lawyer, they can, if a lawyer loses a case, then it's the fault of the lawyer. That's the lesson that I thought I learned at that time. It's the fault of the lawyer. The lawyer is to blame if they lose a case. Now, if I went back into time, I would have challenged some of the matters. I would have done certain things differently. But the decision, well, it's not a warning.
Asta este. Eu vă spun
It's
adevărul
just
așa.
as it is. I'm just being very honest with you and calling things their names. I have no intention whatsoever to hide anything under the carpet.
And you just said that one of the lessons learned is the issue of making sure that the accounting, that the bookkeeping is done better. But also in terms of the way you represented the client, do you also see that there were some, call them shortcomings in the way you represented? Would you do that differently now?
Nu, deloc
No, no, not as far as representing my client. I think that, well, Mr. Chair, well, now it's hard to put it into words. I'm not sure you will believe it, but I took everything I could, every measure that I could. I did everything in my power as a lawyer to get that person out. I mean, as a defender, because I wasn't a defender in a civil case, but as a defender, I think I took all measures possible. Even in the hearing, there would be some confrontations with the prosecutor. We would focus on the different measures. By the way, there are two applications of appeal with regard to the preventive detention measures, one in August and the second one in January. So I believe that I did everything that I could. There was an expert review, two expert reviews were carried out, and I think I did every measure I could to defend the client. We could go back and look into the file. We can look at that, and I am ready to show you each and every detail of it because I remember it by heart by this time. But the commission took the decision. I should have challenged it, but I didn't.
Okay, thank you. Nadezhda, go ahead.
Thank you, Mr. Caisîn. There is another matter that we'd like to address. It has to do with a ongoing criminal case where you are one of the concerned parties. But before that, we'd like to ask you whether you agree with reviewing this situation in an open session, or do you want it to do it behind closed doors? Because we could also do it. We can do it in an open hearing or a closed one. Well, it's up to you. I will leave it up to you. Whatever you decide is going to be fine. Fine, then we will have an open meeting then, if you agree with that. So yet again, we will try as much as possible to avoid using some data that could probe into the privacy of your life or of other people's lives. On the 15th of June 2022, a criminal case was initiated against you, and on the 19th of July 2022, you were charged with the offense provided for in Article 287, paragraph 1 of the Criminal Code, that is hooliganism. According to the copy of the charges against you that you made available to the Commission, on the 24th of May 2022, there was a quarrel, an altercation between one of your neighbors, and we will hereinafter call that person the driver and his wife. The driver stepped on a tree planted by the children living in your neighborhood and did not want to remove the car to put the car away, although several neighbors and children asked the driver to put the car in a different place to save the tree. And you punched the driver with your fist around his head, causing him a light bodily injury, and you also slapped the wife of the driver on her face and caused an insignificant injury damage. I will read out of the charges now, and then you will be able to you will have the opportunity to provide explanations. In your statements of the 4th of July 2022, you stated to the police that you could not hold your emotions and that you hit the driver who fell on the ground, and that your wife helped him stand back, and you understood that he was drunk. At that moment, the driver's wife appeared, and she was shouting at you and pulled your hair. As response to that, you pushed her with both of your hands, and the driver attacked you, and you pushed him back, and after some quarrel, the situation calmed down. In the written answers to the Commission, you confirmed that the criminal case was pending in court. And you mentioned that you pled not guilty and submitted a copy of the charges against you, as well as a complaint regarding the charges that you submitted with the prosecutor's office on the 3rd of August 2022. In that complaint, you challenged the legality of the charges against you of 19th of July 2022 on several procedural grounds, and you requested the prosecutor to declare it null and void, to declare the charges null and void. And you also submitted to the Commission two contravention protocols regarding the driver and his wife, these contraventions committed by the latter. And the driver was fined for illegal parking on the 24th of May 2022, and his wife was fined for inadequate behavior on that same day. According to the information available to the Commission, on the 15th of February 2023, there was supposed to be a court hearing with regards to this case. So now we will move on to asking the questions. Please confirm the facts above, and if there's anything that you disagree with, please tell us what that is. Please pay attention that the bodily injury was on the driver was because he fell down, and there is also an expert's review that is annexed to the case file. He was under the influence of alcohol, so he didn't step right, and he fell down. But the light bodily injury, according to the expert review report, was due to him having fell down. Do you allow me to explain the situation altogether, or only the question, so you can explain it? Well, it happened that the thing is that that person has parked a bus next to the playground for children, and there was a tree, a young tree, or a tree actually already. It was quite a tree. I mean, I sent you the pictures. You could see that it's already a tree. And there was this some sort of a fence around it, so we took care of it. I helped with planting. I mean, the children were there, with the children together, they planted the tree. The situation was that only later I realized, you see, he was drunk, and I should have, if I knew he was drunk, I would have called the police immediately. I did realize that he did drink a little bit, but at that time he trampled over the tree, and there was the wife and the neighbors and everybody was asking him, can you move the car like 2 meters away, 2 meters forward? And he would just wave them away, wave them away. So that's what I understood. Then I came outside and I asked him to, I started yelling at him and telling him to move the car forward. And then he said that he was drunk and that he was not able to sit behind the wheel because he was drunk. But I was telling him, let's push the car with our hands then, because just like 1 meter away that it needed to be moved. So that's what happened. And then his wife came out and I pushed her away from myself because she came all of a sudden. He fell. We were trying to lift him up. My wife was there and I saw my wife couldn't lift him up herself, so I wanted to help lifting him up. And his wife jumped at me and pulled my hair, and I pushed her away. So you confirmed that you were accused of hooliganism. Yeah, but that's not hooliganism. I mean, I never even had this intention in my mind to... And you challenged that the charges, yes, but unfortunately the court, I don't know. I haven't, these methods of the prosecutors, on the same day we're looking into the case file, 5 minutes later the case file is sent to court. I mean, let me look at it and write a request, an application. I mean, what is the point of that? Looking into the case file materials. And then I wrote an application with the prosecutor to have that document cancelled, and so that the procedure is reopened, so that we actually do this confrontation between the parties, all the other procedural steps. Unfortunately, the case file had already been sent to the court, and the court looked into that application at the very end of the examination of the whole case file, so that's what it was like. Understood. Is there anything that you would like to tell the Commission about some new circumstances? If there's the hearing in February, did it happen? No, 2 witnesses were heard. No, yes, two witnesses were heard In May? Was it May? Oh, if our next hearing is scheduled for May, either the 2nd or the 3rd of May.
Înțeles. Um,
Understood.
acum,
So
din rechizitoriu
now,
iese că
looking into the charges, it turns out that you did hit. Yes, I slapped the driver. So you confirm that you slapped the driver. Yes, I confirm.
Că ei așa era, uite,
It just, the attitude was so,
nu cum decideți, eu
I mean,
asta decideți dumneavoastră.
I will leave this up to you to decide. I believe that I might have, I mean, maybe I should have called the police when I saw that he was drunk, but I didn't know he was drunk right away. I only realized it later. But you know, this attitude, like carelessness, he didn't care about it. There were the children there. The children were very emotional too. They were telling him, take the car away, because they planted the tree there at the end of the day. So it's up to you to decide if I did not act manly. And the wife, did you push the wife? Did you slap the wife? I just pushed her like 1,000,000%. I pushed her away because she grabbed my hair like this. I was lifting him up and she grabbed my hair. She was mad and she grabbed my hair like this, and I just pushed her away like that. And because she says that I hit her, but I did not hit her. I mean, understood. So you said now, post factum, you think that you should have rather called the police. Yes. I mean, he was my neighbor. Yes, he lived there for like 2 or 3 years around that. We've been living there since back in, we've been living in that neighborhood. I mean, I've been living there since 2008, and my wife she grew up there in that neighborhood. And he was sort of a new neighbor. Maybe he was a neighbor at the end of the day, so maybe I should have called the police. But it's just the situation was unfolding right there in front of my eyes. There's been this yelling and screaming, take the car away. I told him a couple of times, 3 or 4 times, take the car away, over and over again, or let's move it together by pushing it. He didn't want to. He would just wave us away. He would just wave us away like that. And you said that since he was a neighbor, then sort of as a neighbor, you should have. But in general, like when you see a situation like that, you hit him. Why did you hit him? Why didn't you call the police right away? Because I tried to act in a manly way. And if he wasn't your neighbor, then you would have called the police, or would have you acted in the same way? I can't answer this question. I mean, it's hard now for me to imagine that. I mean, there's a lot of tension. There. 3 women there screaming at him to take the car away. He was there standing, and 3 women yelling at him, take the car away. So there was a lot of tension in the air. And I went out and I realized something has happened since there was all that ruckus. So I was trying to figure out what was happening. And I told him to take the car away, and that's what happened. So if you believe... But from your point of view, do you believe that their behavior on that day, on the 24th of May 2022, does it raise any ethical issues? Considering that, I mean, for myself, well, considering your participation in this competition for the position of member to the SCM, you see, it was a situation of a very minor damage, a minor importance, maybe. However, considering that, well, this, now if you compare it with the competition for the position of member now, thinking bad about it on reflection, this doesn't look right now, considering also the competition. And I think perhaps you've already decided that you're going to fail me. But that's how I just acted in the spur of the moment. In my opinion, the situation that was unfolding was absolutely inadequate. And then I realized that he was drunk. And as for the injuries, bodily injuries, it was not because of my hitting of him. It's because he fell down. And that's also reflected in the expert review report. And I just wanted to highlight this thing. He was moving back, and he misstepped, and he just fell down, just like that. So just if the court will agree with the charges and the court decides you're guilty, then this conviction, would it affect your possibility to practice law as a lawyer? Certainly, it would certainly affect it. You mean in the future? No, I don't think that. I mean, there will be some disciplinary matter, something of a disciplinary nature will happen, I believe. However, there's nothing I can do to change about it now. Is there anything you would like to add in this regard? In this regard, I would just like to ask you to take into account the fact that I just acted as I felt at that time. I never, was involved in cases of corruption and stuff like that. But at that time, the situation was full of tension and strained, and I don't know. I think any other man would have acted. I mean, you're telling that person 3 or 4 times to take the car away, and it just doesn't happen. And then it was my act on the spur of the moment. So it's up to you to decide. Thank you. No further questions to ask.
Since there no other members of the Commission are having any questions for you, this will bring us now to giving you the opportunity to make a brief closing statement to the Commission, and then we will wrap up. But please go ahead with your closing statement right now.
You mentioned that the ethics questionnaire was in July, early July. Unfortunately, I did not speak about this criminal case because I found out about it at the end of July. I didn't know about this case going on, so please do take this into account. It was not my intention to hide anything away from you, so do not treat it as something that I would have wanted to hide. And all the revenue that I earned, I told you and declared to you that as regards the situation and all my temper with that person earlier now, I would like to kindly ask you not to really give it too much. I mean, it was not a severe situation, nothing too bad. It was something light. And I'm happy that I worked with professional people like you and like the members of the Commission and the rest of the team of the Commission. And thank you very much for having allowed me to communicate to you my position.
Thank you very much. With this statement and with our questions, we come to the end of the hearing. I thank you for being with us this morning and for answering all our questions. The Commission will now withdraw for deliberations, and as much as possible, we will strive at delivering a decision in your case within a month after the date of the hearing. I hereby declare this case or this hearing closed, and thank you again for being here with us. Thank you.